Judge Beryl Howell, senior judge in the District of Columbia, has decided that she's not going to stand idly by and let Donald Trump declare himself to be a king or a dictator and do a power grab before her very eyes. And in a new ruling, a 35-page ruling, she just ruled against Donald Trump and ordered that Gwen Wilcox, a very accomplished labor lawyer, be reinserted into her position in the National Labor Relations Board, finding that Donald Trump fired her without cause, which is illegal and unconstitutional under our three co-equal branches of government model. More importantly, not only does she say he's not going to be a dictator and a king on her watch, and she knows her watch pretty well, because Beryl Howell was the presiding chief judge of this same court and presided over many aspects of the criminal prosecutions of Donald Trump. She's the one that stripped the attorney-client privilege away from his lawyers, finding that there was more likely than not they were committing a crime or a fraud, forced them to testify against Donald Trump. She's the one that authorized the subpoena at Mar-a-Lago that he rejected and refused to acknowledge, which led to the search warrant at Mar-a-Lago. She's presided over many Jan 6 cases all the way through sentencing. She presided over Rudy Giuliani's case, in which he was sued, and there's a $150 million judgment against him for defamation because he's an election denier. So let's just say she knows her way around Donald Trump and MAGA. And now in her new decision, she said, enough is enough. You are misinterpreting the law. You are unconstitutional. You are rogue and out of control, and I'm going to order it to stop. I'm Michael Popok. I'm not going to stop. I'm here on Legal AF, the YouTube channel, and here we go. 3 decisions in the last 72 hours, 3 judges, separate judges, all ruled the same thing using the same body of law. What's the common denominator of all 3 cases? Federal workers are being and federal officers are being fired by Donald Trump, and those that protect them are being fired by Donald Trump. 3 different entities: the Office of Special Counsel, which protects people, federal workers firing; the Merit Protection Service Board, same kind of thing; and now Gwen Wilcox being fired from her role, second 5-year term on the National Labor Relations Board, protecting what else? Workers' rights. What's the common denominator? You can see it. All Democrats appointed by Biden, confirmed by the Senate. In Gwen Wilcox's position, no president in 95 years since its establishment has ever fired a board member from the National Labor Relations Board. She also happens to be the only black member on the board. And Donald Trump says, you have to let me fire everybody because I am the unitary president. I am the king and I am the dictator. And Beryl Howell says, you're not. And let me read to you from parts of, it's 35 pages, but I'll give you the highlights here. And let's start with the conclusion on page 35. The president, Trump, seems intent on pushing the bounds of his office and exercising his power in a manner violative of clear statutory law to test how much the courts will accept the notion of a presidency that is supreme. Defendants cite in their briefing Trump versus the U.S., the immunity decision, to argue that the removal power is conclusive and preclusive, with the result that the president need not be subject to criminal or civil legislative constraints. Nowhere in the immunity decision does it say that Congress can't do a check and a balance. The courts are now faced, Judge Beryl Howell continues on page 36, are forced to determine how much encroachment on the legislature or our Constitution can bear and face a slippery slope towards endorsing a presidency that is untouchable by law. The president has given no sufficient reason to accept that path here. The Constitution and case law are clear, the judge continues, in allowing Congress to limit the president's removal power and in allowing the courts to enjoin the executive branch from unlawful action, a role for both in the 3 tripartite system of government that we have, the 3 branches. Under our constitutional system, such checks by design guard against executive overreach and the risks such overreach would pose of autocracy. An American president, Beryl Howell concludes, is not a king, not even an elected one, and his power to remove federal officers and honest civil servants like plaintiffs is not absolute, but may be constrained in appropriate circumstances as are present here. This is not the first time that Beryl Howell has laid out the existential fight for the soul of America this way. She did it before the election at, I think, an ABA conference, where she said almost the same thing about a slippery slope towards absolutism. She then got attacked by MAGA. I think it was Elise Stefanik, who's now the UN ambassador for Trump, who came out with a letter when she was a congressperson calling for her impeachment because she said the obvious truth. In fact, Beryl Howell believes this is so important that the first 3 or 4 pages of her decision doesn't even mention Gwyn Wilcox or the NLRB. It's all about this fight between those who believe in the unitary presidential model, right? Led by a guy named Steve Calabrese, a law professor, conservative law professor, and those who believe that that's a myth, like Cass Sunstein. And people break into one of those 2 categories. The question is, where is the United States Supreme Court going to be on this? I can tell you right now, Gorsuch, Kavanaugh, Alito, and Thomas are unitary president people. They're monarchists, Alito especially. They're absolutists, right? And so they're okay with the dictator king thing. I doubt they'd be okay if it was a Democrat, but they're okay when it's Trump. The other 3 on the Democratic wing of the Supreme Court, of course, don't believe that. They believe that it's a myth, that it's been used by out-of-control autocratic presidents to grab power. Question is Roberts and Amy Coney Barrett, because I don't think Amy Coney Barrett subscribes to that theory of unitary president, imperial president. And I'm not sure about Roberts. I don't think he does either, but we're going to find out really, really soon. MAGA's worried about Amy Coney Barrett because she's now the swing vote. She often sides with the other side. And they're starting to attack her. That's how I know she's doing the right thing. When MAGA starts calling Amy Coney Barrett, who Trump picked in the waning days of his administration and shoved her in to replace Ruth Bader Ginsburg, and they're attacking her now as Amy Commie Barrett, and which is weird because Donald Trump's in love with communism and Putin, and attacking her for having Haitian adopted children. Oh, here we go. She's probably doing something they don't like. So the first 3 or 4 pages is all about that. Let me just read to you from some of this will be the most quoted sections. If you go to page 4 of her 36-page opinion and the footnote, she takes on Trump directly. She says, a president who touts an image of himself as a king or a dictator, perhaps as his vision of effective leadership, fundamentally misapprehends the role under Article 2 of the Constitution. In our constitutional order, the president is tasked to be a conscientious custodian of the law, albeit an energetic one. That's a term that never went together with Donald Trump. A conscientious custodian of the law. To take care of effectuating his enumerated duties, including the laws enacted by the Congress and as interpreted by the judiciary. 3 branches, co-equal, checks and balance. At issue in this case is the president's insistence that he has authority to fire whomever he wants within the executive branch, overriding any congressionally mandated law in his way. That he cannot do. Then she cited when she said he's not a king or a dictator, she hoisted him on his own petard. She quoted his posting, the White House posting on February 19th, declaring himself a king. Long live the king. We have a cover photo of it here. And then later, in all of his interviews while he was running, he said, Trump says he won't be a dictator except for day 1. That means I'm going to be a dictator. Citing some other real Donald Trump, citing he who saves his country does not violate any law, meaning he can't ever be violative of any law because he's trying to save the country, and the rest. And then she does, she pulls a quote from Louis Brandeis, very famous, very influential member of the Supreme Court in the 1920s, first Jewish member of the United States Supreme Court. And here's what he had to say about the friction that's required between the 3 branches in order for us to have checks and balances. Louis Brandeis said the following. Now, this was a dissent, but you can see how powerful of a imagery it is. Checks and balances were established in order that this should be a government of laws and not of men, observing further that the separation of powers was not adopted to promote efficiency, but to preclude the exercise of arbitrary power. The purpose was not to avoid friction, but by means of inevitable friction, incident to the distribution of the governmental powers among 3 departments to save the people from autocracy. Citing Myers versus the United States from 1926. We need the friction. Donald Trump wants to grease it. He wants to remove it. He wants to make it more efficient, have more power, be easier. That's why he admires dictators like Orban and the guy in North Korea and Putin, because he wants to be that. And he's going to push the limits. As I said before the election, if he gets elected again, we're going to be lurching from one constitutional crisis to another. And that's exactly what we're doing. What happens next? These 3 cases, now that she's been reinstalled into her chair, these 3 cases are going to travel together. the one about Hampton Dellinger, the special counsel, the one about the Merit Protection Service Board, and now about Gwynne Wilcox, the National Labor Relations Board. They're going to go together. First, they're going to have to take a pit stop at the D.C. Court of Appeals. We've got one ruling already, and it's not great. It said that Hampton Dellinger needs to be removed from his chair again while they continue the appeal. I don't love that. I mean, the major case in this area of all three cases is a case from 1935 called Humphrey's Executor. It's just the name of a case. But it had to do with President Hoover, of all things, removing a member of the Federal Trade Commission. And the Supreme Court said, no, Congress said you can only do that for cause, and you have no for cause. That is the dispositive case. It's been reaffirmed in 1958, in 2010, and in 2020 by subsequent Supreme Court cases. Donald Trump says, ignore Humphrey's Executor. It's been rolled back. It's almost meaningless. It's not true. You know, every time the Supreme Court takes a look at a limited check on the president's ability to fire a federal officer, they've agreed to it. And they should agree to it again now. As Beryl Howell pointed out, the Constitution is silent about how you fire or remove a federal officer other than for impeachment. So we have to do it through case law and historical precedent. So we already have a 3-judge panel, though, that ruled that Humphrey's Executor apparently doesn't apply or shouldn't apply to the Hampton Dellinger case. We're waiting for a new 3-judge panel to rule about the Merit Protection Service Board removal. And then we'll have another appeal about this one. These 3 appeals, whether they agree or disagree, Supreme Court sometime over the summer. And we'll find out as Donald Trump continues his full frontal assault on the federal workplace and therefore on Americans by removing federal workers who know what they're doing, who are faithful civil servants, who are experts in their field. We're left with what? Phones ringing off the hook when you try to call Social Security or Medicare, try to go to a national park, try to collect our money through the Internal Revenue Service. That's where we're at right now. I'll continue to follow it right here on Legal AF. Help us get to 500,000. We're so close. We're going to hit it this weekend with your help. Hit the subscribe button. Till my next reporting, I'm Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.